Chitty on Contract is my favourite book of all time, said nobody ever. But lawyers in the case of CFH Clearing Limited and Merrill Lynch International may wish that they'd had a copy to hand after the Court of Appeal handed down its judgment on the 14th of August 2020. The case concerned litigation that developed out of the depegging of the Swiss franc to the euro in January 2015. Beginning in 2011, the Swiss National Bank had pegged the Swiss franc to the euro at 1.2 Swiss francs to 1 euro. In essence, the Swiss National Bank had committed itself to doing whatever was necessary to maintain this exchange rate. What would this entail? Well, broadly, it means that the Swiss National Bank might have to get its hands dirty by intervening in the market. More specifically, if the value of the Swiss franc rose against the euro, for example, if it reached parity, whereby 1 Swiss franc was equal to 1 euro, the Swiss National Bank would have to sell Swiss francs, driving the price of Swiss francs down, and buy euro, driving the price of euros up, in order to restore the rate to 1.2 to 1. Conversely, if the value of the Swiss franc fell against the euro, for example to 1.4 Swiss francs to 1 euro, then the Swiss National Bank would have to buy Swiss francs, driving the price of Swiss francs up, and sell euro, driving the price of euros down, in order to restore the desired balance. Why were the Swiss National Bank doing this in the first place? Well, this had been in response to the financial crisis in the Eurozone. The financial crisis of 2008 caused investors to shun the euro and flock to the Swiss franc in search of a safe haven investment. The influx of investment into the Swiss franc after 2008 had caused it to soar in value. We can see how the Swiss franc appreciated against the euro after 2008. In turn, this had harmed the Swiss economy, because exports had become more expensive and therefore less competitive. Fast forward to 2015. There was an expectation that the US Central Bank, the Federal Reserve, was on the verge of increasing US interest rates. All other things being equal, this would have caused the US dollar to strengthen against the Swiss franc, and therefore the Swiss franc to weaken against the dollar. Perhaps more importantly though, the European Central Bank was also expected to embark on a programme of quantitative easing. Quantitative easing is the process whereby a central bank purchases fixed income securities from the market. This is designed to increase money flow within an economy which, in turn, is supposed to stimulate lending and investment. The mass purchasing of securities by central banks has the effect of driving up the price of those securities, which effectively drives down interest rates. We can see that the value of the Swiss franc against the euro had held pretty steady since the peg had been implemented in 2011. However, with Eurozone interest rates expected to go down as a result of the ECB's 2015 quantitative easing programme, the expectation was that the euro would weaken against the Swiss franc. Why? Because investors would sell out of the euro and buy into the Swiss franc in search of better returns, thus driving up the price of the Swiss franc and driving down the price of the euro. In terms of maintaining the peg, this would have required the Swiss National Bank to sell Swiss francs and buy euros in order to bring the value of the Swiss franc back down to the desired level. The Swiss National Bank printed extra Swiss francs to use to purchase euros. However, this led to concerns about the potential for spiralling inflation in Switzerland. In turn, this created pressure on the Swiss National Bank to take action to end the peg. On the 15th of January 2015, the Swiss National Bank folded under the pressure and did just that. The demise of the peg caused the Swiss franc to immediately surge in value against the euro, increasing by about 30%. The Swiss franc broke parity with the euro to be trading at 0.8052 Swiss francs per euro, before settling back to trade at 1.0350 Swiss francs per euro. Overall, the extreme volatility in the Swiss franc lasted about 40 minutes. How does this relate to CFH and Merrill Lynch? CFH was in the business of providing foreign exchange liquidity to its clients. It did this by trading back-to-back with a number of banks, including Merrill Lynch International, MLI. CFH had 3 contracts in place with MLI. Firstly, a 2002 Ejusdem master agreement dated the 27th of June 2013. This incorporated the 1998 FX and currency option definitions, but the parties had not specifically catered for market disruptions. Secondly, a foreign exchange confirmation agreement dated the 10th of July 2013. And thirdly, MLI's terms of business, which had been emailed to CFH on the 14th of November 2013. The MLI terms of business were stated to apply to all investment and connected business between the parties, but were subject to any documentation relating to specific transactions between the parties. In addition, Clause 7 of the terms of business stated that all transactions are subject to all applicable laws, rules, regulations, howsoever applying, and, where relevant, the market practice of any exchange, market, trading venue, and or any clearinghouse, and include the FSA rules, together the applicable rules. In the event of any conflict between these terms and any applicable rules, the applicable rules shall prevail. The volatility in the Swiss franc, which followed its depegging from the euro, triggered the automatic closeout of a number of positions of CFH's clients. Presumably they included some kind of stop loss. In turn, this caused CFH's automatic trading system to close out related hedging positions it held with its liquidity providers. A total of 348 closeout trades were placed by CFH on the morning of the 15th of January 2015. 27 of those trades were placed with MLI around 9:47 a.m. Central European Time. The 27 MLI trades were orders to sell euros totaling 20,479,000 euros at the next available price against the purchase of Swiss francs. Bear in mind that these transactions were being executed electronically. As such, MLI filled the orders it received from CFH almost instantaneously. In addition, they were not subject to any kind of price limit. To make matters worse, in the midst of this market volatility, MLI was showing very low prices for Euro-Swiss franc trades, perhaps signalling that it didn't want to do business until markets settled down. As it turned out, the MLI trades were executed at rates between 0.14668 and 0.2011 at an average rate of 0.1821969 Swiss francs, way off market. To put that in some kind of context, the closing Swiss franc euro exchange rate the day before, in other words on the 14th of January 2015, was 1.0918. Selling 20,479,000 euros against the purchase for Swiss francs at that point would have netted 22,358,972 Swiss francs. In contrast, selling 20,479,000 euros at an exchange rate of 0.1821969 would have netted just 3,731,210 Swiss francs. In fairness, this isn't quite the way it happened in reality. The official low of the Swiss franc euro exchange rate on the 15th of January 2015 was later confirmed as being 0.85 Swiss francs to €1. A number of CFH's other liquidity providers, including Barclays, UBS and JP Morgan, subsequently agreed to reprice any CFH trades executed below this level back up to the official low of 0.85. MLI wouldn't go this far, but it did agree to reprice at 0.75 Swiss francs the following day, the same day that it terminated its prime brokerage relationship with CFH. That being the case, CFH ultimately sold its 20,479,000 euro holding for 15,359,250 Swiss francs. In high-level terms, CFH claimed that MLI should have offered to reprice at the official low of 0.85 Swiss francs in the same way that some other dealers had done. If so, as we've seen, this would have netted CFH a total of 17,407,150 Swiss francs, rather than the 15,359,250 Swiss francs it did receive. As such, CFH's claim, after repricing, amounted to 0.1 Swiss francs per euro, 2,047,900 Swiss francs in total. CFH argued that the effect of Clause 7 of MLI's Terms of Business was that an obligation to comply with, quote, market practice of the foreign exchange markets was incorporated into the Ejusdem Master Agreement between CFH and MLI. It contended that MLI's failure to reprice the trades at the official low of 0.85 Swiss francs was a breach of this obligation. It pointed to three additional factors in support of this argument. Firstly, MLI's alleged off-market pricing. Secondly, the willingness of its other liquidity providers to reprice at the official low. And lastly, the November 2013 edition of the Model Code, which is the International Code of Conduct and Practice for the Financial Markets. This encourages electronic trades which are executed at off-market prices to be cancelled or modified. In a unanimous judgment given by Lord Justice Phillips, the Court of Appeal held that an obligation to act in accordance with, quotes, market practice was not incorporated into the terms of the ISDA Master Agreement. Why? First, the Court approved the statement of Justice Briggs in Lomas and Firth-Rixson that the ISDA Master Agreement is one of the most widely used forms of agreement in the world and is probably the most important standard market agreement in the financial world. It should, as far as possible, be interpreted in a way that serves the objectives of clarity, certainty, and predictability. As such, any suggestion that the parties had incorporated, quote, market practice generally into its terms must be treated with considerable caution, as it would undermine the objectives of clarity, certainty, and predictability. Second, the words subject to documentation relating to specific transactions, as used in MLI's terms of business, did not mean that market practice was incorporated into the ISDA Master Agreement. Rather, it meant that, in the event of conflict between the terms of business and the ISDA Master Agreement, insofar as both related to the 27 MLI trades, then the terms of the ISDA Master Agreement would prevail. Third, the Court did not agree that the Model Code could override the terms of the ISDA Master Agreement. On the contrary, it considered that the Model Code actually encouraged counterparties to enter into an ISDA Master Agreement in the interest of promoting legal certainty. So why then look to override it? Fourth, even if, quote, market practice had been incorporated into the ISDA Master Agreement, the concept was too vague and uncertain to constitute a contractual term. Specifically, the Model Code did not provide sufficient guidance on the subject of repricing, which lay at the heart of CFH's allegations, to lead to a contractual obligation. Fifth, the Court also correctly regarded CFH as a sophisticated commercial party, which entered into automated transactions at the next available price without specifying a limit. In these circumstances, it saw no reason why CFH should not be held to its bargain. Finally, the term, quote, market practice was construed Ejusdem generis. Ejusdem generis. Remember that from your first year undergrad contract law module? No? Ejusdem generis is Latin for of the same kind. The concept describes a rule for the construction and interpretation of statutes and contracts. The rule states that, where a list details specific classes of persons or things, and then refers to them in general terms, the general statements only apply to the same kinds of persons or things as are specifically listed. As an example, if a law refers to automobiles, trucks, tractors, motorcycles, and other motor-powered vehicles, the term vehicles would not include airplanes, since the list was of land-based transportation. In this matter, the phrase quotes market practice appeared in the context of the following sentence. All transactions are subject to all applicable laws, rules, regulations however so applying, and where relevant, the market practice of any exchange, market, trading venue, and or any clearinghouse, and include the FSA rules, together the applicable rules. In the event of any conflict between these terms and any applicable rules, the applicable rules shall prevail. The court held that, in this context, the principle of Ejusdem generis meant that the phrase market practice was qualified by reference to exchanges, markets, trading venues, and or clearinghouses. As such, the word market was clearly a reference to specific and identifiable markets with their own rules, rather than to markets generally, for example, the FX markets. What can we learn from this case? Well, it's clear that if you want to trade derivatives and it goes wrong, don't expect the courts to bail you out. At least not if you've simply made a bad deal. It's also equally clear that if you want to incorporate some other terms into an industry standard contract like the Ejusdem Master Agreement, then don't beat about the bush. You have to be unequivocal as to what they are and the fact that they apply. Failing that, assume that they either won't be incorporated or they will be unenforceable on account of being too vague. Perhaps the most interesting aspect of this case, well, I found it interesting anyway, is that it reminds us of the importance of our basic legal training. To effectively negotiate trading documentation, lawyers must understand so many aspects of how financial institutions and markets operate. From credit, market and operational risk, through collateral management and settlements, to regulatory change, to name but a few. We overlook the fact that, when stripped back, the Ejusdem Master Agreement is just another commercial contract, albeit towards the far end of complexity. All of the elements discussed in Chittian contracts are there in full view: formation, consideration, performance, capacity, agency, representations, interpretation, assignment, breach. It's not often that obscure legal concepts such as Ejusdem generis appear in cases involving the Ejusdem Master Agreement and the Court of Appeal. It's nice when they do, though. It's enough to send us scurrying for our first year contract law lecture notes. It's enough to remind us that, when all is said and done, there is no substitute for understanding the black letter law, because when negotiating an Ejusdem Master Agreement, nobody else will.